All rise. Superior Court is now in session. The Honorable Judge Mark Lemay presiding.
Okay, good morning. Please be seated. All right. We are on the record with State of New Jersey versus Paul Caneiro. It's indictment 19-02-283. Can I have the appearances of counsel for the record?
Morning, members. The prosecutor, Nicole Wallace, on behalf of the state.
Morning.
Good morning, Judge Chris Decker, Assistant Monmouth Prosecutor for the state.
Morning.
Good morning, Your Honor. Monica Mastalone on behalf of Mr. Caneiro, who's present in court.
Good morning, Andy Murray, also for Mr. Caneiro.
Morning. Good morning, Mr. Caneiro.
Good morning, Your Honor.
All right. So we're here this morning as it relates to the defendants coming up on the 2-year cap of the time clock for under criminal justice reform. Let me give a little bit of history on this. Defendant was arrested and charged on November 21st, 2018 with aggravated arson in violation of NJSA 2C 17-1A1 for the fire of his own home. His first public safety assessment issued on November 21st, 2018 recommended release with the condition of monthly reporting. On November 29th, 2018, defendant was additionally charged with 4 murders: the murders of Keith Caneiro, the murder of Jennifer Caneiro, the murder of JC, and the murder of SC, all in violation of NJSA 2C 11-3A1. Possession of a firearm for unlawful purpose under NJSA 2C 39-4A1, and possession of a knife for an unlawful purpose under NJSA 2C 39-4D. The defendant's second public safety assessment, issued November 29, 2018, recommended no release subject to life imprisonment. On November 29, 2018, the state filed a motion for pretrial detention. A subsequent order to detain with no bail was issued on November 29, 2018 by the Honorable James J. McCann. Judge McCann held a hearing on November 30, 2018 pursuant to the state's motion. On November 30, 2018, Judge McCann signed a pretrial detention motion order which states, quote, "The court finds by clear and convincing evidence that no amount of monetary bail, non-monetary conditions, or a combination of monetary bail and conditions would reasonably assure the protection of the safety of any other person or the community." Further, the order indicates defendant consented to pretrial detention. On February 25th, 2019, defendant was indicted under Monmouth County Indictment number 19:02-0283 on 4 counts of first-degree murder, 2 counts of first-degree felony murder, 2 counts of aggravated arson, 2 counts of possession of a weapon for unlawful purpose, 2 counts of unlawful possession of a weapon, 1 count of theft of movable property, and 1 count of misapplication of entrusted property, and lastly, 2 counts of hindering apprehension of oneself. On May the 7th, 2025, defendant filed a motion to suppress the digital video recording seized in the early morning hours of November 20th, 2018, when first responders were tending to the fire at the defendant's home. Defendant asserted that the warrantless seizure of the DVR violated both the 4th Amendment of the United States Constitution and Article 1, Paragraph 7 of the New Jersey Constitution. This court ruled to suppress the DVR on June 24th, 2025. The appellate court affirmed the decision on August 8th, 2025. On September 3rd, 2025, the Supreme Court of New Jersey granted the state's motion for leave to appeal and granted, in part, the state's motion for acceleration. The Supreme Court set an expedited schedule and ordered the state's brief to be served and filed on or before September 17th, 2025. Defendant's brief to be served and filed on or before October 1st, 2025. An oral argument to be heard during the session of November 3rd or November 5th, 2025. Defendant's 2-year cap under the New Jersey Criminal Justice Reform Act is set to expire on September 14th, 2025. Voir dire for the defendant's trial was set to begin this past Monday, September 8th, 2025, with thousands of prospective jurors summoned. Due to the state's appeal pending in the Supreme Court, voir dire was rescheduled to January 5th, 2025. The issue this court is now faced is whether defendant's release on September 14th, 2025, pursuant to the Criminal Justice Reform Act's 2-year cap on pretrial detention is required, or if the 2-year cap may be extended. For defendant's release to be mandated, the period during the state's leave to appeal must not constitute excludable time attributable to the defendant, and the state must not be trial ready. The defendant makes 2 primary arguments in its brief submitted September 9th, 2025. First, the state maintains that the time frame of this appeal is attributable to the defendant's irregular course of filing his motion to suppress the DVR. The state contends that because the motion is where the appeal stems from, the excludable time must be to the defendant. Second, the state argues that it is trial ready, and the sole reason it cannot proceed is because of the appeal pending in the Supreme Court. The state requests this court attribute the excludable time to the defendant in the interest of justice, given that the defendant's motion to suppress was not filed until May 7th, 2025, which is 5 years post-indictment. While the state makes clear it is in no way blaming the defense counsel for the timing of the motion to suppress the DVR, or any other filings for that matter, the state argues that the defendant's motion to suppress spawned the appeal to the Supreme Court, and therefore excludable time is attributable to the defendant. In support, the state contends that it has not contributed in any significant way to any delays in this case, pointing to the defendant's Olenowski motion and again to the motion to suppress the DVR. At the heart of its argument, the state acknowledges the unparalleled circumstances which contributed to the timing of the motions in this case. However, the state presents the court with its alleged options if the 2-year cap is not extended. Either abandon its right to appeal or release a defendant charged with 4 murders. The state cites NJSA 2A:162-22B1C in arguing that interlocutory appeals are excludable from the 2-year time clock because the appellate court in State versus Washington determined that interlocutory appeal is considered a motion. That's State versus Washington 453, NJ Super 163,203, Appellate Division 2018. The state also cites NJSA 2A:162-22B11 in the alternative, arguing that the court may grant excludable time for good cause. Under this framework, the state asks that this excludable time be attributed to the defendant because the delay is reasonable and does not originate with the state. In relying on State's Exhibit 2 and 3, the state conveys to the court that it was trial ready on 2 separate occasions, August 25th, 2022 and March 25th, 2024. In that same vein, the state submits that it is still trial ready, and the only reason why it cannot proceed to trial is that it is exercising the right to have the Supreme Court of New Jersey hear its appeal. The state again emphasizes that the defendant filed the motion to suppress in an irregular manner, and had the motion been filed normally, the state would not be in this position. For this reason, the state maintains the position that it is ready to proceed, meaning the 2-year time cap should be extended. The state ends its brief arguing that the defendant poses a substantial and unjustifiable danger and that the state's delay was not unreasonable. Defendant's principal argument is that the Criminal Justice Reform Act mandates that he be released on September 14th, 2025, because he has not been brought to trial and the state is not ready to proceed. Defendant relies on NJSA 2A:162-22A2A. The statute states in relevant part that a defendant shall be released from jail after a release hearing if 2 years after the court's issuance of the pretrial detention order for the eligible defendant, excluding any delays attributable to the defendant, the prosecutor is not ready to proceed to voir dire or opening statement. NJSA 2A162-22A2A. The defendant argues the state is not ready and that State versus McElroy Davis only deals with the question of what happens when the state is ready to proceed to trial but is unable to because of the COVID-19 pandemic. In other words, defendant argues that McElroy Davis is only applicable when the prosecutor and defendant are ready to proceed to trial, but the court is unable to proceed because of unavailability of courtrooms attributed to the pandemic. Defendant asserts that since the court's inability to proceed to trial is not related to the COVID-19 pandemic, that McElroy Davis is inapplicable. Regarding excludable time, defendant maintains the period pending appeal is attributable to the state, and only time attributable to the defendant can extend that 2-year cap under NJSA 2A162-22A2A and Court Rule 3:25-4D1. Defendant reiterates the state is not trial ready, and if the state was trial ready, the status of the readiness expired once the state decided to pursue the appeal to the Supreme Court. I've tried to give a basic framework of what the briefs that were supplied to me have indicated. Prosecutor, I'm going to start with you.
Thank you, Judge.
So my question to you is this. At this point in time, as you stand here today, is all of the discovery in this matter complete?
Judge, I believe all the discovery in this matter was complete. Obviously, there was one issue with respect to some of the financial records, which was rectified after a request from the defense, and that was prior to, it was post plea cutoff, I believe, but it was obviously prior to trial. It was rectified. We hadn't heard anything objection-wise thereafter. So yes, the state is prepared, has provided discovery to answer that one simple question.
All right, so the discovery is complete as far as you know. And based upon what we've accomplished over the past year, to your knowledge, are there any other substantive motions?
There are not, Judge.
Okay. Is there any anticipated superseding indictment that's being contemplated?
No, sir.
All right. Are your witnesses available to proceed to trial?
They are, Judge.
All right. And is the prosecution ready to proceed to trial?
Judge, we are, and I think even just a cursory review of e-courts specifically, because that's where the court, the AOC tracks both trial readiness and excludable time. It indicates prosecutor ready days being 1,663 days. The court, I think, succinctly summarized the procedural history of this matter, which is a very difficult task. Ms. Wallace and I, with the exception of Mr. Caneiro, are the only ones that have been here for the entirety of this case from its inception. As the court noted, the state did on 2 occasions with respect to a directive that was released by Director of the Courts, Glenn Grant. We had filed the trial readiness letter on 2 occasions under McElroy Davis. While that is accurate with respect to the trial readiness letters, McElroy Davis talks about how it should be done either in writing or on the record. That was also done on the record by both from the state and also with respect to the state answering Judge Oxley's inquiries regarding trial readiness, pretty much at the culmination of almost every conference that I can recall thereafter. I mean, it was a lot of times that the state asserted this. Now, I understand the defense's argument, and as the court accurately stated, and I try to make it clear, I've said this numerous times, I am not here to blame Ms. Mastalone, Mr. Murray for doing their job and doing their job thoroughly. What I think needs to be clear in the record in consideration of whether or not the Criminal Justice Reform Act intended to have someone like Mr. Caneiro in these circumstances, which are extremely, difficult to really analyze from procedural history given the passage of time. Did Criminal Justice Reform Act intend for this 2-year cap to now expire as a drop dead date and have Mr. Caneiro released? The state submits that under the totality of the circumstances, as, you know, we laid out in our letter and as the procedural history would dictate, that is just not what was intended. Think about, I think, what needs to be thought
Well,
about.
let's start with the fact that, did you find any case law that supports your position that says that because the state's leave to appeal is a result of the defendant's motion, that the court can grant excludable time to the defendant?
Admittedly, Judge, no, but I think what is interesting about both Washington and DFW in talking about excludable time, I think, is that they don't necessarily, for instance, with Washington, they don't necessarily say it's attributable to the state under the, what is it? Sorry, under C, under subsection C in the statute with the filing of the motion. They don't necessarily say it's attributable to the state. Now, I understand that, you know, what ultimately a fair reading is going to be and what the argument is going to be is that the motion was filed in May. Okay, it was culminated, excludable time to the defendant upon this court's issuance of its decision. That being said, when they talk about in Washington, I think, and also it was Washington or DFW, they talk about that subsection L in the statute, CL or 1L. It talks
Isn't
about-
that under the 180 clock?
Judge, I don't,
When you're talking about whether that for excludable time for a motion being filed, is that what you're talking about? Or are you talking about something else?
I think when we talk about excludable time, it doesn't, I think it applies equally to 180 versus the 2-year. It's just a matter of the 2-year.
Who is it attributable to?
Correct, because the 2-year time frame can only be attributable to the defendant. And so I guess the answer to your question, Judge, is that we have not found case law which has had an opportunity to evaluate these particular circumstances, in my humble opinion. I don't know that this is a situation that is yet to be contemplated by a court under the Criminal Justice Reform Act. So the argument, as the court pointed out, I guess to some extent has to be, this was not contemplated by the statute. And also the fact that the procedural history would make equity indicate that the state was put in this position because the motion here, for whatever reason, was filed post plea cutoff, post actually the discussion of this issue in the Watson hearing, and then 5 years after an indictment is issued. The state.
But can we say it's post plea cutoff when we know the real procedural history behind what happened here? I understand what you're saying and what happened in December, because I was a part of the case at this point in time. There's obviously circumstances that don't need to be discussed right now that led to where we are. So I understand where you're coming from. Isn't the question here whether under these circumstances you're ready or not? And then other than that, there's a lot of other things that you put in your brief. I can't consider whether he's a danger or not. I can't consider whether he's going to flee or not. That's not what the cap talks about. But what I can evaluate under these circumstances and under the court rule is that, are you ready?
I completely understand the court's kind of centering in on the issue. And I agree. Ultimately, the state is here to say, we were trial ready. We are trial ready. This court no longer has jurisdiction. Everyone agrees with that. Obviously, I'm not.
Well, the parties agree to that.
Parties agree to that. I think the court had said it previously, but the parties agree to that. Under Ms. Maslone added some also additional language from the court rule, which would all indicate that this court no longer has jurisdiction. Is that the fault of the state by virtue of the fact that we filed the motion and it was granted and we chose not to withdraw our appeal, which I think we would actually have to do is file a motion to withdraw our appeal.
Let me focus in on the issue that I see, and then you can feel free to keep going. The issue that I see is, what does ready to proceed mean? Does it mean that you actually have to physically be ready, or does it mean that you have to say that you're ready? And under these circumstances, does that matter?
I think it does, Judge.
So tell me why.
I think, first of all, trial readiness is ready to go. We were ready to go. We were here days, I think we were here that day, the day that the Supreme Court issued the order. We were here just, I believe, that Wednesday in the morning, we had a conference where we were discussing jury selection. The state was ready to go. The state had, quite frankly, essentially forgotten about its own appeal. And it would have been withdrawn had we not gotten this, in my mind, sort of an out of the blue email from the Supreme Court saying, we want to hear this. So we were ready. We spent the entirety of the summer, 7 days a week, and even before that, dealing with motions, but then dealing with trial prep with respect to witnesses and meeting with witnesses and preparing ourselves, writing an opening statement, talking about jury selection, preparing the questionnaire. We were trial ready. The only reason this trial didn't go is because the state exercised its right to have the Supreme Court hear this, which quite frankly, under many other circumstances, Judge, I could see the court saying, well, you made that choice. You know, you could have done something different. You didn't have to do it at this late hour. We didn't do it at this late hour. We've been here for almost 7 years. We actually, in the beginning of this case, and I hope I'm not diverting from your question, but yes, we are trial ready. We are, we were, we will be, we always have been. But we were taking, as I put in my letter, we were taking excludable time for, I think there's 386 days of excludable time that was attributed to the state early on in this case. Because, you know, so that the defendant, so we could get him the discovery, so he could review it. Fast forward all this time, he's still reviewing his discovery. Like, I don't know what was going on for that time frame early on, but like the fact, when I look back at the fact that the state wasn't fighting excludable time being attributable to the state, when, you know, it took 2 years to file a motion for a Fry hearing when we were contemplating at the time pre-cutoff, and it didn't happen, and that's fine. But, you know, then we sat around waiting for defense expert reports, and it was fine because Mr. Caneiro was agreeable to it, right? And he was agreeable to it when they filed motion for leave to appeal in the Supreme Court. But now, all of a sudden, I just don't feel like Criminal Justice Reform Act meant to treat the state so much differently than the defendant when it has done nothing but proactively try to move this case to trial to the best of its ability and be trial ready, which it was, is, and will continue to be.
So I'm going to ask you the question again, because I don't think that you clearly answered me.
Okay.
My question to you is that under these circumstances, based upon a read of the court rule, and I'll give you the court rule, 3:25-4D3, the administrative directive under 06-22, and McElroy Davis, that under the circumstances, is the question that I'm asking you whether that you're ready, meaning that you're telling me that you're ready, or do you physically actually have to start the trial?
Well, I don't know that you physically have to start the trial, because then I don't think there would be any question about whether or not someone was trial ready. So I think you can be trial ready without actually proceeding to voir dire and opening statements.
So there's my answer. So now my next question to you is that I read, and Ms. Mastellone is going to correct me if I'm wrong, I read her brief on behalf of the defendant to say that McElroy Davis should be narrowly construed. And again, I could be wrong, but that's how I read it. And in reading it that way, even if I read it the way that Ms. Mastellone wants to read it, or is the court confined to the court rule and or the directive that indicates that I'm asking you whether that you're ready to proceed and you're telling me that you're ready to proceed?
The questions of, I completely understand the question. I think McElroy Davis talks about that. The directive talks about that. It can't be as simple as, Judge, you asked, I said, Judge, we're trial ready. It has to mean something. And that's why we lay out in the letter, and it's laid out in the directive, those 4 questions that you asked for. Like, are we ready? Did we prep for this trial? Yes. Did we meet with witnesses? Are they available? Is the discovery done? Is there any more motions? No. Are we going to supersede the
You don't need, see, I'm trying to frame it a little bit as easily as I can. There is no doubt both sides were ready to proceed the trial, 100%. We did have that conference. The way that the conference ended last Wednesday, the court said, I'll see you Monday morning at 8 a.m. to start picking a jury. So it's not a question to this court whether that you are ready to proceed or not. we're ready to proceed last Wednesday. My question is right now, under these circumstances, are you ready? And your answer is yes, I'm still ready from before this court at this point, according to the consent order and the arguments that were made last Friday, that this court does not have jurisdiction until such time that the Supreme Court renders its decision.
I think there's a couple questions that the court has. I'm going to leave that last argument alone because I couldn't disagree more with that argument. But getting to the specific issue of trial readiness, I think it was argued that McElroy Davis is very specific to the issue of the pandemic. What McElroy Davis ultimately does is kind of puts together with the directive those four questions, and one of which is not in there is this solely due to the pandemic? So that, I think, the argument to be made is that McElroy Davis is not that specific, and it does not have to be a natural disaster. They had facts that included that before them, but I don't believe that the holding there with respect to trial readiness would contemplate the necessity of a pandemic. And specifically at page 235 of McElroy Davis, it talks about prosecutor's statement of readiness does not end all concerns about defendant's continued detention. The overall structure of the CJRA in section 26 in particular made clear the legislature was concerned about lengthy pretrial delays for detained defendants. Yet a statement of readiness can effectively extend the 2-year cap in a defendant's pretrial detention if the court is not able to proceed. Putting fault aside, this court is not able to proceed. Also in DFW at page 440, that's 468 NJ Super 422 at 440, the court says, we next consider defendant's argument regarding the 2-year clock. Defendant argues that a prosecutor cannot be ready to try a case if there is no courtroom, jury, or judge available, as during the COVID-19 suspension. So the prosecutor was ready in February 2020. She was not ready after the April 6, 2020 trial date came and went. The court said, we disagree. So they're not limiting this issue to natural disasters. I think in this situation, we exercised our right to appeal, and I'll leave those. I think the procedural history has been played out and set forth in a manner in which the state disagrees with the contentions in that respect. But the state, in this case, and I think the words that were used by Ms. Massalone at times, I think quoting McElroy Davis, maybe DFW, is capable to start trial, prepared to start trial, genuinely mean it. We genuinely mean that we are and were prepared, capable of starting trial. And I think given the lack of jurisdiction of this court, because of the appeal, this court lost the ability to proceed to voir dire, despite the state's readiness, despite the defendant's readiness. And I think that is ultimately the question that the court needs to decide.